trial date. Set a trial date.
I'm trying to get this dismissed. This is this is literally holding me back right now.
You get it dismissed on the date of trial. Date of trial.
Nice. Thanks for no, I see clear as day why I'm not getting the same courtesy. Your name is Sean Perkins? Yeah, okay. I will.
That's the last time I checked.
Yeah. Okay, I get it.
Mr. Gubin.
I don't need to hear it. I don't need to hear the blabby blab. Just stop talking to me.
I was just gonna ask, did you want to go in a breakout room?
What is a breakout room? I showed all my proof. I showed all the proof. I showed the proof, Mr. Sean Perkins. What is it? Is it my what is it? My complexion?
Have a good day,
it's my complexion, isn't it, buddy?
Have a good day,
Mr. Uneducated Judge.
Have a good day, Mr. Gubin. You keep on talking.
How are you even a judge?
I'm gonna hold you in contempt, okay? And we're gonna give you some jail time, okay?
What a clown.
You done?
Anything else?
Are you
Anything
done?
else, pal?
All right. I'm gonna hold him in contempt. I'm gonna give him 30 days Wayne County Jail. All right.
Right. Okay.
I want you to pause here, because this is where everything went wrong. This wasn't about insurance paperwork anymore. The moment he started talking over the judge, dismissing the process, and accusing the court of racism mid-hearing, the case stopped being about tickets and became about control. Courts don't respond to volume or insults. They respond to compliance. And once contempt enters the room, logic usually walks out.
You have an absolute right to a hearing.
You will expect a huge lawsuit. I showed you every single proof of documentation that I needed to, and you refused to dismiss my stuff.
Have a great day.
Why is that?
Have a great day. We're not talking anymore, all right? We're done talking.
Yeah, that's what I thought.
30 days Wayne County Jail.
Yes, Judge. Good morning.
And who are you here on?
This is the moment people online love to argue about. Was the judge too harsh? But here's the truth. Contempt isn't about feelings. It's about protecting the authority of the courtroom. When a judge warns you repeatedly to stop, and you keep escalating, jail isn't emotional, it's procedural. This wasn't punishment for paperwork. It was punishment for defiance.
For contempt last year. I see him hold up a child, and his child, he didn't come down. So again, he continues to defy orders of the court, and we just don't have much to talk about.
Well, Judge, I understand that may be the court's position as it relates to this matter. May I have just 1 second? I apologize, Judge. I needed to plug my computer in. So I understand that may be the court's position. I just got retained on this matter this morning. I was not present at the hearing where you apparently held him in contempt. He obviously has an opportunity to prepare and present a defense to the allegation. I'm not sure if the court made a finding as to whether or not this was civil or criminal contempt, and further, whether the court actually determined whether it was direct or indirect contempt. Obviously, the court's ability to sanction an individual, especially with a deferred sanction, may be limited under these circumstances. So what I'd be asking the court to consider doing is giving me a brief adjournment so that I may obtain a copy of the transcript of the last hearing. And I would just cite to case law, which indicates that my client does have the ability to obtain an accurate transcript of the hearing as a matter of due process. And when we come back, I will be prepared to effectively, properly address this matter.
Well, the contempt was the contempt.
Now the tone changes. The attorney steps in and does what the defendant never did: slow it down. He raises due process, asks whether this was criminal contempt, and requests a transcript. This is how power is challenged legally. Not by yelling, not by accusing, but by procedure. And notice something important. The court actually listens here.
Was right on the record, on the record, and I do have, you can get the record for that. It was, I did hold him in criminal contempt. That's why I told him 30 days Wayne County Jail. And from my understanding of the court rules, he had his opportunity to contest that. That ship has long sailed, from my understanding of the court rules, because this was done over a year ago. And the only reason that Mr. Gubin has come back before me is because he got some other cases. He let the tickets go on the warrant status. He only is before me because he got the other cases. So I still need his presence here. I'm going to readjust his bond now.
Well, Your Honor.
So he continued, I'll let you speak, Counselor, and I'll let you do what you need to do as far as your job, but I'm going to do my job. And Mr. Gubin continues to defy the court's orders, and we'll.
The judge makes it clear this was criminal contempt on the record, with consequences already set. And here's the part most people miss. This didn't come out of nowhere. The defendant didn't appeal, didn't comply, didn't show up. Time passed. Warrants stacked. Courts don't forget. They just wait.
Take no action today and give me the opportunity that I am requesting on behalf of my client. And if you'd like me to transition into the bond issue, I am happy to do that as well.
I'll let you go ahead with bond.
Thank you. Your Honor, it is my understanding that mere traffic matters are pending before the court, at least one civil infraction, and I believe a no insurance misdemeanor. These incidents date back to 2022 based on my review of the Register of Actions. He has appeared in connection with this matter, which the court has noted. Apparently he was here last week, and you may have recognized him. But the point of the matter is, I've known Mr. Gubin for a while. He always appears as required and as instructed. I understand that the court may have a difference of opinion as it relates to that, but I would attest to that. He is a lifelong Michigan resident. He has extremely strong family support. He is a father. He has minor children, actually, one of which is visible on the Zoom as we currently sit here. He owns his own business in Wayne County and operates that business very successfully. I think when you consider factors that are relevant to a bond inquiry and are not relevant to collateral matters such as prior actions engaged in allegedly before the court, personal bond is warranted, and it's my understanding that that is what may have been previously entered in connection with this case. Upon conviction of the only misdemeanor with which he presently stands charged, his maximum sentencing exposure is minimal. He is obviously presumed innocent at this point in time. And for all of those reasons, Judge, in addition to other reasons, such as his lack of any significant or substantial criminal history, which is a factor that the court shall consider when it sets bond, I believe a personal is warranted. And retaliation for what allegedly occurred in the past should not impact bond under any circumstance.
All right, very well. Bond is going to be set at $2,500 cash. I still, the order of Mr. Gubin still showing up because despite what you've articulated on the record, Ms. Bachowicz, I we put the warrant out for Mr. Gubin's arrest a long time ago. He was supposed to be in person here today. He's not. He also has an assault and battery case that he has a warrant out for his arrest for as well. So he showed the court and demonstrated to the court that he has not only with this court, but with the other courts and other judges in this courthouse that he has a failure to appear or something. So bond is $500 cash, and it's still ordered that Mr. Gubin show up in person to the court for the conviction hearing, and we will address and you can appeal the matter to a higher authority if that's what your client chooses to do.
So, Your Honor, I have a comment as it relates to a cash bond. I'm asking that the court impose a cash or surety bond. My interpretation of the court rules as it relates to bond and statutory authority allow the defendant to elect whether he posts a surety or posts a cash bond. And my position is the court cannot outright prohibit a surety. So I'd ask for the addition of a surety provision.
The court has made its ruling, Counselor.
This bond argument is emotional for a reason. Father, business owner, community ties, all real things. But bond isn't a character contest, it's a risk assessment. And when a judge sees repeated failures to appear across courts, sympathy stops mattering. That's why the bond becomes cash. Not retaliation. Not ego. Just history catching up.